Welcome to the Kentucky Workers' Compensation Podcast with Ched Jennings of the Jennings Law Offices. This is a free resource for people who actually work for a living. Ched is going to provide information to help you file for and maximize benefits for injured workers. If you're ready, let's talk about Kentucky workers' comp and related issues. Friends, welcome back to episode 2 of the Kentucky Workers' Compensation Podcast with Ched Jennings of the Jennings Law Offices. Ched, welcome back, guy.
Thank you. Great to be back.
Absolutely. So in today's episode, we're really going to try to give the audience an overview of the Kentucky workers' compensation system, the benefits, and kind of how it works. It's not going to be all of the nuts and bolts, but I think when they come away from this podcast episode at least, they'll have a general idea of how the system works and kind of what they should be thinking about and questions they might want to be asking. Ched, one of the first things that happens, obviously, somebody gets hurt on the job or in a job-related activity, they've got to give notice. Now, kind of walk us through that. What does that mean?
Well, the law requires that notice be provided by the injured worker as soon as practicable. Okay, and so there are people who get hurt on a Friday afternoon and think over the weekend they'll get over it, and they don't. So they come in on Monday, or they're getting ready to leave for a 2-week vacation or shutdown or whatever it might be, and they think they'll get over it, and they don't. So it's as soon as practicable. And the notice does not need to be anything other than it can be constructive notice. It can be all sorts of notice that's provided to the employer. For example, if a wife calls, is that notice? Yes, it's bringing it to the attention of the employer, not a fellow employee, but to the attention of the employer.
So you got to really think your supervisor, your manager, maybe it's HR, somebody above you in terms of the organizational chart.
Exactly. So there's no requirement that you have to fill out a report like within 24 hours or fill out any report whatsoever, or to have to sign a report to meet the notice requirement. It is bringing the injury to the attention of your employer, and that can be done different ways. For example, the employee that got hurt at work and the ambulance came to pick him up, was that a sufficient notice? Yes, it's sufficient notice. I mean, that's where you, at that particular point in time, realize this employee got hurt and needed immediate medical care.
Right. And let me ask you this. You touched on it just now, but it's always a point that I think kind of gets confused. If the company says, no, you got to tell us within 48 hours or you can't file the claim.
It doesn't work. That's not what the law is. Remember, it says as soon as practicable. And so it doesn't say within 24 hours, doesn't say within 48 hours. Years ago, a lot of companies had that requirement and they got struck down.
And so sometimes you're going to see that. And that's probably meant in an effort to maybe dissuade you from actually filing a comp claim.
Well, not maybe necessarily that much, but maybe, I don't know. But what I look at it, the employer has a need to know. Back when this was really passed in the original Workers' Comp Act of Kentucky back in 1916 and 1917, the notice factor was required. And I've actually read notes from people who participated in those enactment of that law. And the notice was there because employers wanted to know and that if there was something that caused the accident, that they would learn as soon as possible so that they could take steps to correct it or fix it so that another employee doesn't get hurt.
And you mentioned that in episode 1. I remember you saying that really it's there for a good reason, but also, again, the employer has a right to know, but also you're, as an injured employee, required to let them know.
Exactly right, and that's a part of the law, and it says that an employee must provide notice as soon as practicable.
Well, let's take a little bit of a sidebar conversation here real quickly. Unlike a car wreck where, I may have property damage to my car, I may have some medical bills, and I may also have pain and suffering, that really doesn't happen in a workers' comp claim, correct?
Correct. And if you visualize, first of all, pain and suffering is not a part of the Workers' Comp Act. I told you about 1916 and 1917. Back then, employees, if they injured themselves at work, had to file civil suit in the circuit courts of each of these state counties. And if they had a thing called contributory negligence, if they were found at least 1% contributory negligence, it was a complete bar.
So if they could prove the employee was just 1% at fault,
yep,
they contributed to the fault.
They contributed to the injury, right?
Game over.
And they wouldn't be able to get any benefits.
That was years. That was
Yeah.
years ago.
Now that got changed by Kentucky. Kentucky went to what's called comparative negligence, and that's in civil cases, not workers' comp. In workers' comp, it's not a negligence. It's a no-fault type statute. The fact is, whether or not you sustained an injury, it's not how you sustained the injury. And there are some things that are in there. For example, if there were safety violations, there would be some penalties. Could be penalties. If the employee was wrong and participated in the negligence, so to speak, and violated the safety regulation, the benefits can be reduced 15%.
It doesn't eliminate them, but it could just reduce them.
Right. If the employer is at fault and the benefits can be increased against them 30%.
Right.
But that's what they did back in 1916, 1917. The business people, if a jury got to cases, juries would bring back big dollar verdicts for pain and suffering, and also dollar verdicts for punitive damages. And that took care of eliminating several companies because of that happened. And so that was their interest. They wanted to get away from having a business liability that potentially could to close their offices down.
Right.
So what they did was they pledged, if you all don't have punitive damage, you have this administrative system. And the administrative system, the benefits are based upon loss of earning abilities, occupational disability, and not pain and suffering. We'll give an early delivery of medical care. We'll pay for that. We'll pay for disability benefits. And so somebody today that gets hurt doesn't have to wait 3 to 4 years for a civil case to be decided. And how they're going to pay their bills, how they're going to pay their rent, how they're going to pay their car payment, how are they going to provide for their family. They get benefits earlier.
That was that big bargain. That was that grand bargain.
That's exactly right.
As a worker, I'll give up the ability to sue for pain and suffering and things like that, but I'm going to be able to get my benefits and some money flowing into my household much, much quicker.
Now, this isn't happening in Kentucky, but it's happening in other states. There are challenges to where the benefit of that bargain has not been reached, or it's being breached today.
Right.
Because the defendants, the employers, are not paying out ample benefits, or they're not being provided their share, and an early delivery of medical care and medical benefits is getting lost. And right now in Kentucky, it's very hard to find doctors in rural areas that will handle workers' comp cases. And that's significant. Where does the injured worker go to get help? And it's not just in the rural counties, it's also occurring up here in Jefferson County. My primary care physician, his firm, which is a Norton's firm, will not take workers' compensation cases. Why? Because of the system that's developed. And we're going to be talking about this in detail in maybe some other podcasts. But the systems that have been developed, it makes it hard for the doctors to treat individual patients.
Right.
Because there's somebody reviewing it that says, no, you can't do that. You can't treat it this way. You can't get an MRI now. You haven't got this done because it requires 6 physical therapies to be done first. And so the doctors, rightfully so, have become very, very disenchanted with workers' compensation cases.
They get frustrated. They're trying to do their work on the behalf of the patient.
Well, Jim, look at it this way. If you get hurt or if you go to the doctor, you want to do what your doctor says. You don't want to do what some doctor who happens to be utilization review working from a cubicle down in Oklahoma or Texas trying to say that the procedure or the treatment that's being recommended for you is not fit or not right or reasonable.
Well, and this brings up another big point as we look at an overview of the overall workers' compensation system here in Kentucky, is picking your doctor. So you've been injured, you've given notice, and you're going to go get some treatment. Let's talk about that, because it's a very, very important fact, or right, I should say, that the worker should understand, right?
Yes, and that's the first thing that I basically talk with my clients about from the get-go. We mentioned notice, but the main thing is we start talking about the health care that they have received or not received. And you have some employers who are big enough that they have medical doctors on their plant location. Ford comes to mind. They have Ford Medical. And then you have small employers, but they have insurance companies. And those insurance companies will tell those employers, if somebody gets hurt, we want you to send them to these doctors who are occupational doctors. and I call them company doctors, but because basically those doctors are there for the company and the insurance company, and not for the injured workers. But they basically will then do the evaluations, and they have the right to have an injured worker evaluated. I'm not trying to take away from that. Yes, they can send you to a doctor for that. But one thing they've not taken care of getting rid of, which I think is important, and in Kentucky, you still have the right to pick your doctor for treatment purposes. You can pick what pharmacy you want to go to. You can pick what doctor you want to treat with. Now, there's a thing called managed care, and a lot of times people will say, well, it's a managed care group. You don't have that right. Well, no, you do. Each managed care program has a list of doctors who are participating in their managed care that you can pick from. And I tell a lot of my clients, just ask the insurance adjuster to give you that list.
Right.
And on that list will be doctors who, the reason they have a list, they have to agree to charge so much, or their bills to be so much, or the fee schedule, whatever it is, to become a part of that list. And so managed care can be helpful, but it also is one of the barriers that I see thrown out there trying to take away the right of injured workers to basically pick their doctors for treatment. And I don't think there's anything more important. Nobody listening to this, including you, wants to be told what doctor you have to go to for treatment.
Exactly.
It's just not right.
And so would you recommend they go to their primary care physician first? I would think that doc's got a vested interest in making sure his patient, you, the injured worker,
Right.
gets the best treatment possible.
Well, if I go to my doctor's going to say, sorry, we don't treat workers' comp cases.
Right. In your situation,
And
because
yeah,
of the norm
and that's here in
goes.
Louisville.
Yeah.
Okay. But the main thing is, I try to recommend that they at least talk with and the doctor will see you. Go see him. And everywhere you go to a doctor, you want to basically, it's very important. You want to make sure that you give them the injury history. They're supposed to ask, but you want to make sure that you make sure the records reflect that you had the injury history. Secondly, is that they will submit the bill. Okay, they will get a response from the insurance company whether or not they're going to pay for their bill. And it matters to the doctors that they know they're going to basically be able to treat.
Right.
And it hurts the treatment history if they are provided these utilization reviews or doctors from other states saying, no, you don't get the opportunity.
And what exactly is a utilization review? You've used that term a couple of times.
Well,
what is that?
Again, years ago, they had a problem with the cost of medical care. And I know it sounds, I'm taking you back. When I started in the mid-'70s, of every dollar spent in workers' compensation, 35% of it went to the doctors for medical treatment. The rest of it went to administrative costs, say 10%, and the rest of it went to injured workers for benefits. Well, that changed. A few years ago, it became 70% of each dollar spent on workers' comp goes to the doctors. So years ago, they decided to come up with fee schedules to make sure that they were being billed correctly. And they also want to make sure they were treating. They didn't want somebody going in and seeing a doctor and then turn around and have a neck fusion surgery the next day. So they wanted to put in these controls to permit people to review, okay, what medical treatment's being recommended, and that become a process of the approval for care. And so you'll have patients who are turned down by the workers' comp people, but they're able to go ahead and get it done by Medicare or get it done by Blue Cross Blue Shield or one of their private insurance companies who have their review systems too. But the bottom line was that was the intent on utilization review. And that happened several years ago. There were a lot of people on the insurance side not really interested in seeing that, but it has helped put some handcuffs on the spiraling costs of healthcare in Kentucky, and especially in workers' comp cases. And it helped shorten, the ability for that. And so the numbers, the last time I think I saw a study done, and I can't point you to the study, it may be the Workers' Comp Research Institute. I'm not sure, but last time I saw a study, I think the cost for medical care in Kentucky has now been reduced down to 60%.
Okay.
So it's dropped at least 10 points.
So let's talk a little bit about these benefits. We talked early on that the big bargain was, hey, we won't be able to get pain and suffering here, but we'll be able to get the money flowing to the injured worker. So one of the benefits under Kentucky Workers' Compensation System is temporary total disability, TTD benefits. What is that?
Well, a lot of people, TTD is a term that a lot of people that don't know. I mean, I'm not just talking about non-lawyers. People at work, HR people, supervisors, and claimants. They don't know. The term I like to use is workers' comp benefits.
Right.
These are the benefits that you're supposed to get while you recover.
This is while you're under active medical treatment.
Right, and while you recover. Now, there's two caveats to that. The benefits are payable until you reach medical maximum improvement, and that's a medical term. That's when the doctor says you're going to get as good. This is as good as you're going to get. You know, your ongoing problems are permanent. Okay, you had neck surgery, you have pain now. You know, you're as good as you're going to get after surgery. Once they see the quality of the fusion, they say you're at MMI.
We've done all we can do, basically.
Yeah. So those workers' comp benefits, at that point, the disability benefits, what we call temporary while you're recovering, they are over. Okay, now, what's also over is if your employer decides to accommodate your restrictions. And when this first came in, there were some abuses. There were employers who would have people come in and sit in the cafeteria and do nothing the entire workday. They get their regular paycheck, but they would do nothing, which was terrible for their treatment and treating people that way. There are some employers that will send their injured workers, say, to the soup kitchen downtown to contribute to help, or to the kennel to help, do like whatever work they can do. But that's not really the way this is intended. But there are employers who bring people back, and they truly try to accommodate the light duty restrictions that their doctors have them under. And that's important. It is important to bring people back to work. It is important to bring them back gradually, slowly. I'm seeing a lot of cases now, as you can imagine, with the pandemic. There's a lot of employers that have been shut down. Some of the bigger ones come to mind, especially the car people. And what's happening is they're taking people, and people are starting to go back to work, and they're working again, which is great, but they're physically, they haven't worked for 2 months, so they're physically, they need work hardening. They need to get back up to the same level of being able to lift 600 windshields a night, or however it might be. And so it's really different times right now, but I applaud the efforts of every employer that tries to bring people back in a good way, to give them light duty and try to work with the restrictions they get. Because really, when you look at workers' comp, it's the medical community, the employers, and the employees. And what's the overall goal of really, it's to get people back to work, back to being productive, having their productive lives, and being able to do their work.
So, assuming they've gone through all of the treatment they can get, they've had some surgeries, maybe multiple surgeries, the doctors have looked at the records, they finally said, okay, we're at MMI. Your maximum medical improvement, this is as far as we can take you. At that point, you go through something that actually yields what's called an impairment rating. How does that system work? What is that?
Well, years ago, again, to become a little bit more objective, it used to be you'd ask the doctors, and the doctors would say, well, I think the rating's 20%. You'd have another doctor saying 50%. There was really no guidelines.
It was very, very subjective, right?
Very, very subjective. And today, years ago, again, they asked for, there was a movement through this country to go to what's called the AMA guidelines, and they've had different editions. When we first started, I think it was the first edition, but we're in the fifth edition, and they've had later editions. But Kentucky decided to stick with the fifth edition. They looked at it years ago and said, we're going to stick with this because everybody's gotten used to it. Everybody, the doctors know, they use the tables, they do the ratings, and the concept is, if you have a loss, if you go to every doctor, each doctor would come up with the same rating. So, for example, if you lose an eye, your rating is 25%. What's the 25%? It's 25% to the body as a whole of your loss of function. So if you lose an eye. If you have a cervical fusion, you're going to be between 25 and 28%. If you lose a finger, 6%. If you lose a thumb down to the first index, it's 11%. Down by the palm, that knuckle, you're talking about 22%. So they come up with what the rating is. Now, even with the book, doctors can disagree, okay? And you have evaluating doctors, which I hope we'll talk about at some point in time, and you also have treating doctors. Some of the treating doctors don't do the ratings. They've sent them out to doctors who do those type of measurements. They'll have a functional capacity evaluation done to say how much they can lift, how much they can do repetitively with the twerking of their arms, all sorts of stuff to come up with what they think the restriction should be and what the ratings are. Ratings are basically based a lot on loss of motion. You know, if you have a shoulder injury, can you raise your arm up, fully extended above your shoulder level? Can you raise it all the way above your head?
Well, especially if you're on the line working overhead. I mean, that's a critical motion.
It is. And a lot of people that have shoulder injuries, torn rotator cuffs, they don't get to go back to doing online over-the-shoulder type work.
Right. So you've got this impairment rating. There's also an option that you may be looking at permanent benefits at this time.
Well, that's it. That's the next part of it. The temporary benefits are then over. Then the question is, what about permanent benefits? And that's for people who've sustained a permanent injury. And that's why you have the ratings from the AMA guides, because that rating represents a permanent partial impairment. Now, the first thing to determine is whether or not the injured worker at that point is totally disabled. Does he have an injury sufficient enough to medically disqualify him from going back to any type of work, or to find work that he can keep and maintain for the sustained and indefinite future? In other words, he can do that type of work, and it's important because that's a big thing if you're totally disabled. And you would get those benefits right now. There's some cases testing this, but at least to age 70, okay? No matter what you want to look at, but could get those benefits up to age 70. You have permanent partial disability benefits if the impairment rating that we talked about is greater than 34%. Then you get benefits for 10 years, 520 weeks. If it's less than that, you get benefits for 8 years or 425 weeks, approximately 8 years.
And so that's how long that, again, the workers' compensation system is going to be sending payments to you to help, with a little bit of everything.
Yeah, the law provides for weekly benefits.
Right.
Doesn't provide for lump sums. Now, parties can agree to a lump sum, but provides for weekly benefits paid to the injured worker. And so when you look at it, you're starting now to touch upon, there's a formula we have.
Right.
And again, this will be but you start off with average weekly wage, and you start off then with the impairment. The second part that you need to know is what's your impairment rating that you were talking about, permanent partial impairment rating per the treatment guidelines, the 5th edition of the AMA guidelines, American Medical Association. The doctors all got together and published what they considered to be the tables and how you would rate these people. And there's doctors who disagree. There's always disagreement everywhere.
You got to start somewhere.
But you plug that in. Then the next big part of workers' comp, there's a table. And the table it has a certain percentage. And the concept was if you have a 5% impairment rating, you should probably have that discounted, because somebody that's got a 25% impairment rating is a much greater impairment rating. So they should be bumped up higher, and the lower ratings ought to be reduced. Now, when I say that, what they did was, and it's however they came up with this, I can't tell you. I don't want to say they picked it out of the air, but I will tell you.
Sometimes it feels that way.
From 1 to 5%, they do 65%. So
of what?
Of the 5%. So instead of it being a true 5%, it works out to be 3.5. If you have a 10% rating, from 6 to 10, it's 85% of it. It's reduced down to 85% of it. So, 85% is 8.5% instead of 10. So it's, again, these cards have been, in my opinion, stacked against the injured worker, and it further reduces their benefits. Now, if you have a higher impairment rating, let's get up to, like, for example, 30%, you increase them 35%. So you'd multiply your rating by 1.35, and that would give you a much greater disability benefit.
And of course, everybody loves doing math, and math, when you're listening to it, makes not a lot of sense. But that's an important reason to get your attorney involved, because they're going to go through this. One, they're going to look, is it fair?
Yeah.
And sometimes there's a good chance that you're going to dispute that, and then you get into these medical disputes. What really is a medical dispute?
Well, the medical disputes are any time that there's a disagreement over treatment, and that's usually between the doctor who's treating you, recommending, and the insurance company or the self-insured saying, no, we're not going to pay for that. Now, it could be as simple as prescriptions. It could be as simple as an MRI being done. Big thing they fight over are these injections, cervical or lumbar steroid injections, surgeries. Surgeries are closely looked at.
Well, they're very expensive, and the insurance company is saying, "Do I really want to pay that out if I don't have to?" And they're going to argue the point.
Well, and so then what ends up happening, that's where the system comes into play. They basically reach out to their friendly doctors who will say, no, the surgery's not work-related. They'll reach out and say, we don't think it's reasonable or necessary. They'll send it off to UR. And by the way, UR is owned and operated by the insurance companies.
And again, that's that utilization review.
Utilization review. It'll be sent to some doctor down in Texas who works in a cubicle to say, no, I don't think this surgery is necessary, who's never seen the injured worker, never met him.
As opposed to the treating physician right there who's working with you to say, no, I think it's warranted. It's something that the worker should have. And again, this is the reason that really you've got to have an experienced attorney on your side. You've got to have someone who, one, has the experience, because I've seen this, or I'm sorry, I'm not an attorney, but you are. You've seen this over and over and over. You kind of have a feel for what's going on here. And no, there's a time to fight on behalf of that injured worker. And that's what you do on a day-to-day basis.
Exactly. And what I try to tell everybody, it is a legal system, okay? And, you know, you ask somebody, well, would you represent yourself in court if you were charged with murder to possibly get the death sentence? I wouldn't.
No.
Okay, and would you represent somebody where you could spend any time in jail by yourself, represent yourself and not have a lawyer? No, I wouldn't. So now I come over onto the workers' comp side or personal injury side. When you get involved with that, it's still a legal system, and you don't have to, it's not required to, but it's very highly recommended by me or anybody. You need to have a lawyer to navigate the system that they have.
Right, because, I mean, and I hate to say it, but there are subjective calls, and where possible, they're going to sometimes make that call on behalf of that company who keeps referring them business, and that's why, again, you want to be wary of that company doc that we talked about in kind of episode 1, especially when we talked about, you know, you have the right to choose your doctor. I mean, that's critical. So, again, you're in there fighting for that, and at some point, there may be a need to actually fully file the claim. Up to this point, the system's been working, everything's going, but technically a workers' comp claim has not actually been filed in Frankfurt, correct?
Correct. And I have this conversation.
It's confusing to people.
Well, it is. See, for example, you'll hear, I've already filed a claim. Well, you have. Well, I'm getting workers' comp benefits. They're paying me my workers' comp. They're paying the doctor and all that. So I've got a claim filed. Well, no, you don't. You have to file the claim in Frankfurt. And if you don't file a claim within 2 years,
that's that statute
of limitations, they call it, within 2 years of the date of your injury or the last payment of workers' comp to you while you're off recovering, then they don't have to pay anymore. They stop. They have no obligation, the insurance company or the self-insured employer. And I hate to say it's a system, but you got to remember something. What they don't pay out, they get to keep.
Right.
And I think it's significant to understand that the injured worker needs to basically file this claim in Frankfurt. And this is what he protects by doing that.
He or she.
He or she.
Yeah.
When they come into my office, even if they're being paid benefits, I recommend let's go ahead and get your claim filed. And I'll tell you the reason why. If I have a problem with any medical issue, if I have a problem that they're not getting their benefits on, I can get the judge on the phone. I can have a hearing within a few days. If you file your claim, after that, it takes a few weeks for it to be processed, and you won't get it done for 4 or 5 weeks. So we recommend, I do at least, that you file the claim as soon as possible to make sure you have a real judge who can sit there to take care of resolving particular issues. And I think it's significant to also understand that you have to file the formal claim to protect your rights to future medicals.
Right.
Now, in 2018, the General Assembly took away lifetime medicals, and they passed it, and they limited the medicals to 15 years from the date of injury. But during the last few months of the 15 years, you can file a motion to have your medical benefits extended, okay? And that's something that is, the burden is on the shoulders of the injured worker, and that's really going to be hard. They'll have to, again, find the doctor or the doctor that's treating them, get a report that's filed, get it before a judge, and they may try to do it without a lawyer, or they're going to have to go out and get a lawyer. So there's certain things, there's cost problems at that point in time. I don't think that was very fair to do, but again, I spoke up opposed to it.
Well, and if people listening to this would go out to your Facebook page, the Jennings Law Office's Facebook page, there's video of you testifying there in Frankfurt. I remember we went up, you were at a Senate subcommittee hearing. I believe it was the Senate, wasn't it? Or was it the House?
I've testified so many of them, I can't remember that time.
But it was in Frankfurt, and
yes.
you were really arguing that point that hey, I don't think this is really fair. And it was awesome to kind of watch you with your 45 years of experience. It wasn't 45 at the time, but 45 years of experience in Kentucky's workers' compensation claims, talking to these guys saying, no, this is the workers deserve better. And you were adamant about that.
Well, what I really enjoyed at that point in time, and let's really think about it, that cap applies to all employees. And where I stood and sat, I sat with police officers. And when you really think about it, a police officer, now in today's time, a police officer sustains an injury. Their injuries are a lot of times really a lot worse than other people because they have much more problems being able to go back to work. But they also have long-term medical care needs for injuries. And I was disappointed to see that they were trying to cap first responders at 15 years, much less every other employee. And that's why I spoke. But I was really honored and privileged to sit with the police officers to talk about that act.
Well, and I thought that was such an interesting argument, is that if the injury is permanent, why aren't the benefits?
Exactly. And that's the way it has been. It's not now.
Yep. But that's why you need an experienced attorney on your side representing you throughout this.
The other reason that's important in filing a formal claim is when it's resolved, either through settlement or through a board award, you also have the right to reopen your case for 4 years. And you're able to reopen the rights if your condition worsens. And there's a lot of people, these aren't like car accidents where you get one check, sign a release, you're done, you can't go back. These are cases where you don't sign that release and your benefits still continue if in the event your condition should worsen. And that happens to a lot of people.
Absolutely it does. So we've gone through this long overview, and we still haven't really had that official hearing. The injured worker still hasn't really had his or her, quote, day in court, but that's really kind of the next step in this process, isn't it?
Well, what happens in the process, after the claim is filed, at some point in time, the attorney for the insurance company will take the deposition of the injured worker. And this is taken like a sworn statement. It's just asking questions. What'd you hurt? Where'd you work before? How are your symptoms now?
How did it
Are you
happen?
back to work? How'd it happen? Did you give notice to your supervisor? All those general questions that go with each case. Then they will probably send the injured worker to a doctor for an evaluation. And these are what's known as independent medical evaluations. IMEs, which is really a misnomer because they're not independent. They send them to their doctors for a medical examination. It certainly isn't independent. In our office, we normally send our clients to doctors that do independent medical evaluations, but we're basically getting it done for our benefit, for the plaintiff's side, for the claimant's side.
The injured worker.
The injured worker.
Yep.
Right. And so the thing about it is then if you can't reach a settlement, and there's a mediation aspect that I think I'm really been excited about that we're doing. The chief administrative law judge, Doug Gott, has kind of piloted it, and now there's a reg that's been promulgated, and it's exciting to see it develop. But what's the interest there? Well, if you have a mediation, you can normally get your money within 30 days of the mediation, as compared to having the hearing, taking 60 days for the ALJ to do an opinion or
That's
award.
the administrative law judge.
Administrative law judge. We'll talk more about this in other things, but you get your day in court. You can testify in front of the judge. Judge can hear you and see you, and you can talk about what happened and how it happened. And then they render the opinion. They tell you what you're entitled to. And they do the same thing we were talking about earlier. They take what they think is the most appropriate rating under the AMA guidelines. They read what both doctors say, or 3 or 4 doctors that give whatever opinions they are. And then they run it through the rest of the schedule. Then the big thing, this is something I haven't talked about, is are these injured workers back to work? Did they return to their same job duties? Are they their pre-injury job duties? Did they return and are they earning the same wages or greater wages, or are they earning less? And for those people who don't get back to work and are earning less, whatever, they get their benefits multiplied by 3. They get 3 times what the impairment rating is or the formula reads. They, for people who do get back to work, say the fellow at Ford Motor Company that goes back to the assembly line, goes back to the same job, he doesn't get the multiplier, he only gets 1.
Right.
And especially if he's back to same or greater wages, then if anything happens to his employment and his termination or separation is not due to something like stealing or a thing like that, then he can have his benefits doubled. So there's some provisions in the law that kind of protect, and that's why it's so very, very important. I tell everybody, listen, the right to reopen and medical benefits isn't necessarily money we're getting in now that goes into your bank accounts. It's what you need to have protected for the future. And that's what's really important. So you have to file a formal claim or settle your case to get that done.
And again, that's part of what you do at the Jennings Law Offices.
Right.
Is you walk it through and you take this burden off the shoulders of the worker and you say, hey, look, we're going to handle this for you. We're going to kind of quarterback this whole process and do absolutely everything possible to make sure you maximize those benefits that you're actually entitled to.
Yeah, and what our role is, and I think it's really important. Remember, I told you communication and education. So pledges that we make to our clients is that we stay in touch with them. We want to stay in touch with them. We want them knowing what's going on in their case. We want to talk with them about the evaluations. We want to talk about their pick of doctors, who they choice, and where they get treated. And we also return our phone calls.
That's the one thing I've always admired about you is that you will spend late into the evenings, because you and I have even had phone calls late into the evening where you're just kind of getting back to me, but you're picking up the phone call and you're making that call to whoever it is, whether it's a client or whether it's me or whomever, you're actively doing that. And that commitment to this is one of the reasons I really enjoy working with you.
Well, I'll tell you, one of my, I guess, best compliments I ever received, and this was a client that I'd represented who worked at Ford, and he went to their general meeting, where the union meeting, the UAW got together in their meeting. All of a sudden, I started getting these texts, and they were like, man, you won't believe what's happening here at the meeting. You can't believe this. I don't know who this guy is, but this is what he's saying. And so what he said was he got up and he held his phone up to the ceiling. He said, we finally have a lawyer that will return calls. He's called me on Sundays. He's called me on Saturdays. He calls me late at night. But he cares about my case. He cares about me. And I'm telling you, he fights for your rights, especially with Ford. And with that, I get all these texts. And he says, this is amazing. He says, I bet you that he calls me. I'm going to call him right now, that he calls me before this meeting is over. And he called, and I returned the call.
Lo and behold. That's a man who walks the walk. And Ched, it's a pleasure. But you know, if you're injured in Kentucky, and you know, just because you don't live in the Louisville area doesn't mean you can't work with the Jennings Law Offices. You guys have the ability through online video conferencing. You may have heard of Zoom. You guys can do that. You can do all things by mail or fax or email. A lot of different ways to do this. But again, you have that ability to service the state of Kentucky, which is outstanding. And you know, a lot of times that's as we try to wrap up these podcast episodes, you know, if you've been injured, you've got a lot of questions. Your family has a lot of questions, a lot of things going on, and you're probably under some pressure to get those answers. And that's why we always say it's the Kentucky Workers' Compensation Podcast. It's what you need to know. Ched, I want to thank you for your time. I know you're busy. I know it's been a long day for you, but I appreciate you coming to the studio and helping us out with episode 2 here. And if you're listening on the podcast today, you can get a hold of Ched in a number of different ways. The easiest way to do that is simply to go to the website, www.JenningsLawOffices, it's plural, JenningsLawOffices.com. There you'll have the phone number. You'll have a contact form you can send over to the firm right there online. You can get a connection over to the firm's Facebook page, which is pretty active generally. You can go to the YouTube channel. You can all sorts of things, and you'll find future episodes of this podcast as well. So I'd really encourage you to go out to the JenningsLawOffices.com website if you have some questions, and I'm pretty sure Ched's going to get back to you if you make that phone call or send that in there. So again, thank you very much for listening, and we'll talk to you next time.
Thank you.
Thanks for listening to the Kentucky Workers' Compensation Podcast. We hope you enjoyed this episode. We'll be back soon with more information. In the meantime, if you like what you heard, please consider sharing this on your social media channels. You'll be doing your part to help Ched support injured Kentucky workers.